Sometimes after divorce, something changes, and you might wonder, can I go back to court and change or modify what we agreed to at the time of the divorce? And the answer is that it depends on what you're looking to modify. And in some cases, it also depends what was written in your original divorce order. So let's talk about a few examples. As your children grow, circumstances might change. Unexpected things might happen. You can go back to court to modify how parenting works, what the schedule is, etc., assuming that there's been something substantial that's changed in your lives or your children's lives. That's one thing you can go back to court to modify. Another thing that you can go back to court to modify is alimony if your agreement allows for it. So it depends on a few factors, what your agreement says, and then who's modifying and why, and how much has changed. But in many cases, if something significantly has changed, you can go back to court and modify alimony as long as your agreement didn't make alimony non-modifiable. Another thing that happens post-divorce is sometimes people don't do what they're supposed to do, right? So maybe people aren't following the parenting agreement that got entered as an order of the court. Maybe people aren't paying their alimony when they're supposed to. Maybe they didn't sell the house like was ordered in the court decree, or provide their spouse with half of their 401k if that was ordered in the divorce decree. There are a lot of things that can happen post-divorce that aren't the way that the court orders intended. So what do? Well, it can depend on the circumstances. There are different things that experienced divorce lawyers will file, but generally speaking, one of the most common ones is called a motion for contempt. And what you're essentially saying when you file a motion for contempt is, my ex is in violation, in contempt of the court's order because they didn't do this, or they did this and they weren't supposed to. The term motion for contempt sounds pretty serious, right? It's heavy to be in violation of a court order. Sometimes someone violated a court order because they didn't understand it. Sometimes they violated it willfully, like they disregarded it and did what they wanted to do anyway. How the court reacts to a contempt really depends on why the contempt was violated. So if you want to think about a practical reason, if someone failed to transfer funds from a bank account and they failed to do it because there was an issue with the bank letting them, the court might view that contempt differently than it would someone who just didn't want to do what they had been ordered to do. Can the court fine someone for being in contempt? Yes. Can they make the person who is in contempt pay the other side's attorney's fees? Yes. But generally speaking, what the court is trying to do is just figure out the most efficient way to get its orders complied with. So you don't see attorney's fees awards. You don't see fines and penalties. You certainly don't see someone being incarcerated until their contempt is like really extreme and continuous. It's more, hey, you really have to do this. And then if they comply, which most people do, most people, get on board. But in most cases, what the court's trying to do is make sure the thing that was supposed to happen, or the thing that is not supposed to happen, stops. If you have an issue that's come up post-divorce and you're trying to figure out if you can go back to court to get that modified, or if your ex isn't doing something that they're supposed to be doing and you're wondering whether the court can help you by making sure that they do it, give our office a call. We'd be happy to have a conversation with you about it.